Lordship, the first argument, the first basic premise is that there is political weaponization and that is creating a threat to federalism. Your Lordship, arguendo, it is submitted that the Act undermines the federal structure on flimsy charges. Your Lordship, when it comes to the statement of objects and reason, there is a word allegation. So, Your Lordship, the council is trying to give a thing that assertion that a mere allegation, whether a mere allegation, on the basis of this mere allegation or flimsy charges, they are being arrested, Your Lordship. And it is submitted that the Act undermines the federal structure on flimsy charges targeting the opposition parties by misuse of central investigating agencies like EDCP. That's also mentioned in the moot proposition, Your Lordship, because it is central investigative agencies that they are arbitrarily interpreting into this, and also thereby creating a legal shortcut. So that is a super emergency impact is being created, Your Lordship, under Article 356. So they are trying to do this and to destabilize the government. Also, Your Lordship, federalism and state autonomy. When coming to that, federalism is a core principle as embedded in the basic structure, and that is submitted as the amendment destabilize opposition led state government, and thereby is straining the center-state relations. So here cooperative federalism is also at stake, Your Lordship, and so they are doing this as an alternative way to the president's rule to weed out state governments, thereby the impugned act is a colorable legislation. And automatic removal conflicts with the doctrine of pleasure and emphasizes S.R. Bommai versus Union of India. No arbitrary dismissal of state autonomy without judicial scrutiny. So that is leading to a constitutional vacuum when the PM itself or when the CM itself is being removed by this procedure. Your Lordship, the council is not trying to say that it is the council is against the decriminalization of politics, but the council is trying to prove that only against the basic method. The basic method is here this removal that is amounting to disqualification. Your Lordship, and also the separation of powers that is also being violated here, Your Lordship, as mandated in Article 50. Separation of judiciary from executing in public service upholds judicial independence and obstructing executive interference. And All India Judges Association was Union of India. It was cited that independence of judiciary is the omnipresence of the basic structure. And Your Lordship, the Council brings it to the attention of Honorable Court that the Imbued Amendment Act, by transcending the ambit of the legislative power to of judicial review to executive. Judicial review, that transcending the judicial review to executive, espousing public abuse, thereby is creating a chilling effect of democracy. Our political dissent is being here, and also, Your Lordship, independence of judiciary, that's a constitutional right, and the council places reliance on Minerva Mills versus Union of India, and to submit the unplenary power of Article 368 excludes to alter core or basic structure. This limited amendatory power of Parliament cannot be converted into an absolute one. Reaffirmed in Keshavananda Bharati case and Indira Gandhi versus Raj Narayan case for the removal of doubts, that is there, and for the removal of doubts, basic structure falls outside the competence of Parliament's amendatory power. It will be pointless if Parliament on the imposed restriction goes beyond to alter this basic structure, Your Lordship, and the Council in this regard submits the sacrosanct that for deliberate policy making, Parliament's sovereignty is not absolute. Therefore, it's submitted that the Impugned Constitutional Amendment Act violates the cardinal constitutional right, that is independence of judiciary, Your Lordship, and reaffirm Supreme Court doctrine of implied limitation, Your Lordship. And this implied limitation is on the power of Parliament to amend the Constitution and violation of parliamentary democracy. Your Lordship, parliamentary democracy is considered the basic structure, and P.V. Narasimha Rao versus Union of India, it was cited, and the amendment is described as saving democracy, Your Lordship. As cited, this is not a temporary removal, it's a disqualification, Your Lordship, because the no bar on reappointment is acting as a saving clause. It's not a saving clause, it's a temporary removal is a disqualification. Transferring more power to executive, eroding the democratic principles. The governor supersedes the mandate of will of people, rendering it unprecedented with parliamentary democracy, Lordship, represented by legislature having a deliberate authority alongside act. Additional ground subrogated this delicate balance. When they are adding an additional ground, that is subrogating the delicate balance of the parliament. And also, that automatic cessation is also striking at the parliament system under Article 74 and 75, and it is undermining the democratic principle of voter representation and because there is a manipulation of water, that is also undermined democracy, Your Lordship. The core argument that's mounting the challenge as the mandatory removal of PM and CM on the behest of President or Governor blatantly subrogated parliament democracy as cited in Quijano case. And also, it is underpinning the Westminster style of democracy because where removal from executive position is subjected loss of confidence of the House. So that is being also violated. And also here, preamble is being perverted, Your Lordship, because preamble is given to the people, and it should be mandated that justice should not only be done but ought to be done. And it's humbly submitted that the 130 Constitutional Amendment influenced the doctrine of constitutional morality, doctrine of constitutional right, and institutional governance, opined as the foundation of republican democracy. Fairness in the verdicts must not only be in the preamble, liberty, social equality, but also that should be done in the act itself, Your Lordship. And the fundamental rights is also being negated. The Council would be dealing further in the third issue regarding fundamental rights. But Your Lordship, here Article 14 is violating the criminalization of politics. That is subservient of free and fair election and the basic structure of democracy. Article 19, it is disproportionate and the unreasonable restrictions. These are not reasonable restrictions, it is creating an unreasonable restriction, and there is an element of violation of Article 21 in Maneka Gandhi vs. Union of India. All these rights, the due process is being violated, the fair trial rights is being violated in Article 14. So all these is being violated in the negation of fundamental rights. That's also an argument the Council would like to prove. And the rule of law is misplaced as rule of law. Your Lordship, Dr. B.R. Ambedkar's vision of constitutional morality. There are certain canons of constitutional morality that the minister should abide, and that's also mentioned in the statement of objects and reasons of that, Your Lordship. So here, there is a ray of suspicion, and that is mentioned in the genesis of the statement. There is a ray of suspicion, but that is a selective ray of suspicion, which is given only to the ministers and not to the MPs or MLAs. This unique yardstick of removal on unreasoned incarceration, unreasoned arrest and detention stands trial or conviction. Your Lordship, the maintenance of dignity of court is the sagacious principle of rule of law by Arundhati Roy vs. Union of India, and judicial review is a core part of rule of law. There is also a tool for political vendetta, Your Lordship, because that is creating executive discretion and also politicalization. This twin mechanism of ousting lawmakers, pruning PM or CM's prerogative powers, the prerogative power to select the cabinet. Your Lordship, therefore, trumped up charges is being politically motivated, and that is so that they can shield their allies and also they can target it to their rivals. And hence, it is respectfully submitted the act in question, that's the 130 Constitutional Amendment Act, is eroding this basic structure, Your Lordship. Also, this is not a least restrictive measure, Your Lordship, because there can be interim suspension, there can be other reforms, so that they can preserve their seat that with this interim suspension, and also they can prove their innocence. But in this case, when government servants, when they are within 48 hours custody, they are being removed. But in that case also, they can file an appeal in this administrative review. But such judicial scrutiny is not there here, Your Lordship, and that is being violated. So, unless Your Lordship has a further question, the Council would like to move into the third issue of sub-issue. Much obliged, Your Lordship. So, Your Lordship, the Impugned Act is posing unreasonable restrictions on fundamental rights of Article 14, 19, 21 of the Constitution of India. Argument is humbly submitted. The Council of Petition humbly places it before the Honorable Supreme Court of India, while Union of India was an association for democratic reforms, court through judicial review should step into the ambit of fundamental rights that is irrevocable via an amendment. The Council bases their argument on the following premises. Backlash on Article 40. It is arbitrary and unreasonable action is being caused. It is pertinent to note that, Your Lordships, the twin test of Article 40, that is the rational nexus and also reasonable intelligible differentia, that is not being followed here, Your Lordship. As certainty is a vital aspect of rule of law, it is pertinent to know that the impugned 130 Constitutional Amendment Act is having an arbitrary abuse of power. Also, the non-application of due process and the procedure safeguards, and also amendment is blatantly failing on the arbitrary test while Anwar Ali Sarkar and E.P. Roypa. Criminalization of politics is subservient of free and fair election, and also it is congruent with section 187 of PNSS, and this unequal treatment is also there in the union Your Lordship, upholding equality, the amendments assert that no one is above the law. And Your Lordship, this is a tale of two standards: inconsistency in treatment. Considering MP MLA as one and ministers as another, the Lordships, the Council is trying to prove that MP MLA is just a legislative post and ministers an executive post. From that post they are being removed, Your Lordship, from the executive post. And arguendo, the Act raises the question about rational and fairness. So the paradox lies in inconsistency between legislators and ministers, what the Council had already proven. The RA at 1951 disqualifies MPs, MLAs only upon conviction. Yet, the amendment removes ministers merely on an arrest and detention, creating an irrational double standard. Also, Your Lordship, for example, if a minister is getting a bail within 20 days, in these 30 consecutive days, one minister is getting bail in 20 days, and he's keeping his job. And at the same time, he's keeping his post at the same time. Another minister, on the case of just that person that didn't get the bail, and also he is denied of the fair trial rights, he is removed from that post itself, Your Lordship. And that's a tale of two standards. And here, Article 19 is also being deprived. It is submitted that Article 19 subclause 1, subclause A, and choice of representative subclause C, suppressing the dissent evident in PUCL versus Union of India, and also free and fair election, that's a part of basic structure, that is infringed by these unreasonable restrictions. Openness is mandated in the functioning of government, Your Lordship, and vagueness and overbreadth of serious crime. There is not a definition of serious crime. There is a vagueness in that serious crime is severe, that 5-year imprisonment. And also, that is leading to the arbitrary application, Your Lordship. Thus, non-precise standard regarding what constitutes serious offence. That is what is being here. That is leading to the arbitrary application, Your Lordship. And that is having a disproportionality. It is failing the test of proportionality. There is no legislative aim is not, and also the least restrictive measure that is also not be there, and all these that's having not a rational nexus also, thus failing the test of proportionality in case Mutasami was Union of India. And Your Lordship, abuse of power and disproportionality. And with that, it's also cited in 500 cases, as cited in ED, Enforcement Directorate and CBI. Previous 5-year record only less than 10% conviction. Politically motivated detentions are amplified, which undermines the electoral process. Citing data report from PRS legislative research, only 2 convictions. I would like to assert on stress on the fact that only 2 convictions, Your Lordship, registered out of 193 high-profile cases involving politicians. Conviction rate is just 1%, Your Lordship. Conviction rate is just 1%. This results in disproportionate influence of a state but indirect removal of agencies. No provision for compensation for malicious arrest, and also misuse preventive detention and legal guidelines under UAPA and PMLA. It's a Herculean task to get bail in such cases, Your Lordship. And also, Your Lordship, the Council would also like to state that here the police, the arrest is an executive act. Arrest is an executive act. The amendment allows police-led investigating agencies like CBI and ED to do this executive act. So this arrest is an executive act, Your Lordship. And also, when it comes to the judicial here, how the violation of separation of...
I think we'll hear the second speaker.
Much obliged, Your Lordship. I understand, Your Lordship. Beg your pardon, Your Lordship.
No, the second speaker also.
Okay. Yes, Your Lordship, I understand your concern. If unless Your Lordship have no further question, may I call the Council? Much obliged, Your Lordship.
Council requests a permission to begin. It's obliged, Your Lordship. The Council seeks a permission to address the bench collective desk, Your Lordship. It's obliged. May I please this Honorable Court? This is Council number 2 appearing on behalf of petitioner in the case of Socio-Political Center versus Union of India in this Honorable Court. Lordship, the Council is dealing with issue number 4 and 5, and issues are whether the impugned the 130th Constitutional Amendment Act strike at the foundational principle of the criminal jurisprudence, enunciating that an accused is presumed innocent until proven guilty. And issue number 5, whether the implementation of the impugned 130th Constitutional Amendment Act result in the weakening of the democracy in the Republic of India, warranting its set aside. Your Lordship, it is humbly submitted before the Honourable Court that
Council. Sorry for interruption.
much obliged, Your Lordship.
One question. Whether proposed disqualification is a temporary one or a permanent one till he is found not guilty.
Your Lordship, it's not mentioned that it is temporary disqualification. Your Lordship, it is clearly stated in the own proposition that it's removal. So it's disqualification, Your Lordship.
That is what removal from the post of Prime Minister, Chief Minister,
Your
or
Office,
Prime Minister is a temporary measure or a permanent measure, means till he is found not guilty or till he is released from the custody.
Before conviction, actually, Your Lordship, in the present 130th Amendment Act, they are they are violating the principle of presumption of innocence until proven guilty, and they are removing his the PM or CM or ministers from before making them guilty, Your Lordship.
What I understand from the proposed legislation is that if a minister is facing criminal charge for an offence punishment is more than 5 years and above, and if he is retained in custody for more than 30 days, automatically he will be disqualified from holding the post of minister. But the proviso of the proposed amendment would say that nothing prevents him from reappointment if he is released from custody.
Your Lordship.
Would it be to say it is a temporary measure or a permanent measure?
Your Lordship, it is not temporary, it's disqualification, my Lordship. Much obliged, Your Lordship. It is humbly submitted before this Honourable Court that the 130th Constitutional Amendment Act impermissibly equates mere accusation and 30 days custody with guilt, and thereby violating the foundational principle of the innocence and enabling the removal from the office without trial or conviction, in turn with offending of the Articles 14, 19 and 21 of the
And
Constitution.
one more question.
Yes, sir.
The mooter one argued that before conviction, removal is unconstitutional because it is no judicial entry.
Yes.
But here, proposed amendment speaks about custody. Do you mean to say that custody, whether police custody or judicial custody, ordered by the court, is not a judicial scrutiny?
Your Lordship, before the judicial scrutiny, they are removing the. No, Your Lordship. Before the judicial scrutiny, they are removing the Lordship. And before the trial,
Yes.
much obliged, Your Lordship. It is respectfully submitted that the idea of presumption of innocence states that an individual is always presumed an innocent unless the proven guilty. It is initially spelled out by the jurist Blackstone, who stated that it is preferable to let 10 criminal people go than to allow one innocent people suffer. In the historic decision of the Woolington vs. TPP, her House of Lords held that the presumption of innocence is the golden thread of the criminal law and cannot be endangered, Your Lordship. The 130th Amendment Act, mere arrest plus 30 days custody is equivalent to the guilt, Your Lordship, because it violates the foundational principle of the criminal jurisprudence. Because it is not preventive, it is punitive. Because if a minister is accused for 30 days, serious offences, 5 or more, and custody for the 30 days consecutive days, automatically removed from the High Constitutional Office. And why it's punitive? Because the person loses their office and constitutional stigma attached to them, and the public views them as a guilt, Your Lordship. So the mere accusation is a constitutional punishment, and custody is an automatic removal, Your Lordship. Thus the amendment convert pre-trial detention into the finding of the unfitness, which is another way of saying guilt is presumed, Your Lordship. In In the Chandrababu versus State of Kerala, the court held that presumption until proven guilty is not merely a legal right, but it is a fundamental right to your option. Diluting this principle, because the offence alleged is so serious, would determine the integrity of the criminal justice system and inevitable result in the miscarriage of justice. It is humbly respectfully submitted that the amendment makes mere accusation and 30 days custody for a ground for the removal, effectively turning pre-trial detention into the conviction or into the punishment by treating arresters thereby violating the Article 14, Article 20, and Article 20 requirements of the dignity, fairness, and non-arbitrariness as elaborated in the Maneka Gandhi Lordship. How the Article 14 is violated is this is arbitrary and discriminatory classification because it is a rational distinction and two individuals accused of the same offences, one may be arrested and one not be arrested. There is a removal of the depends upon the police action, Your Lordship. In Your Lordship, it is humbly submitted that no person can be treated as guilty without a fair trial as providing guilty beyond the reasonable doubt. The Impugned Amendment Act by this principle by imposing the laws of the constitutional office on mere accusation without hearing of the judicial inquiry, thereby breaching the OD alternate button, which is a natural justice principle, Your Lordship. Your Lordship, the Council bring into the attention of this Honourable Court that the 75% of the under trials remains in the custody for the years without conviction as per the UAP and PML Act, and nearly 60% are arrests are unnecessary as per the National Police Commission, and the investigation agencies like CBI and ED have repeatedly accused on the politically motivated arrest, Your Lordship. When arrest itself is often misused, the amendments chose to attach the constitutional penalties to the custody rather than the conviction because manifestly arbitrary, Your Lordship. Unless Your Lordship have any further question, the Council seeks to move into the fifth issue, Your Lordship. Much obliged, Your Lordship. It is humbly submitted before the Honourable Court that the democracy is a government by the people in which the supreme power is exclusively exercised directly and through the elected representatives. As recognized in the Mohanlal versus District Magistrate Raebareli, democracy is a concept, a political and philosophical and ideal grounded in the governance by representatives chosen directly or indirectly by the people. The democratic process ensures that equal participation in the democratic process and decision making and protects freedom and more equality, preserve representative institutions that safeguard the minority rights. By enabling the removal from the high elected office on the basis of mere arrest and 30 days custody without any electoral process or judicial finding, the amendment disturbs the representative structure and weakens the public participation and undermines the constitutional democratic, Your Lordship. And Your Lordship, democracy is built on voter sovereignty, and elections are free and fair only when the electorate non-investigation agencies determine the leadership. The 130th Amendment Act shifts the power from the voters to the police to ED or CBI, because any elected person, any elected PM or CM or minister can be removed without conviction, and solely because the arrest can arrest them remain in the custody for the 30 days. This collapses the doctrine in the Mohinder Singh Gill versus CEC. The democracy requires the people alone to choose their leaders. Your Lordship, further in SR Bombay, this Honourable Court held that the democratic legitimacy must be tested on the floor of the House, not through the extraneous factors in police custody. Your Lordship, the reality of the Indica's political landscape cannot be ignored because nearly 95% of the ED investigations since 2014 have been targeting the opposition leaders, and the CBI and the ED have documented that highly partisan issues. As it already mentioned in the proposition that Indica has umpteen example of the partition and arbitrary exercise of the authority by the central investigation agencies, and they are highly prone to misuse and abuse by the ruling suspension, Your Lordship, providing that the minister loses office automatically after the 30 days custody. Incentives the political misuse of the ruling party that may be direct agencies to the intimate criminal process to remove the opposition leaders or destabilize the government, Your Lordship. Your Lordship, ordinarily, constitutionally disqualification allows judicial trial, judicial finding of the guilt and conviction, but the amendment allows police action without judicial finding to cause removal from the highest executive office. The state of Bihar vs. Shubhas Singh says held that the arbitrary exercise procedures violate Article 14 and 21. Your Lordship,
Counsel, I want to put a question to you. A minister holding the portfolio of women and child welfare was alleged to be committed a sexual assault against a child and he was prosecuted under the Presumption of Pope's Act. Do you mean to say that he shall be continued to hold that portfolio as the Minister for Women and Child Welfare?
Your Lordship, could you please clarify the question, Your Lordship?
A minister holding the portfolio of women and child welfare was charged for the offence of committing sexual assault against a child. Would you mean to say that he will be continued in the same portfolio till he is found guilty?
Your Lordship,
Is it good for the country?
Your Lordship, only after the proven by the disqualification by the court, only the judiciary has the power to give the punishment, or only after the conviction he will be convicted, Your Lordship. It's not like Your Lordship. It is humbly submitted before this honorable court that repeatedly held that arbitrary or unfair procedures violates Article 14 and 21. Due process cannot be replaced with executive convenience. The amendment custody base removes lacks of any arrestable connection with guilt or adjudication. Freedom of speech and expression is one of the most cherished values of a democratic society, and it is indispensable for an operative and democratic system. Article 21 requirement of fair, reasonable procedure is violated and a person is removed from the office without being here violating the OD Adrum Patrum solely on the basis of the 30 days custody, Your Lordship.
Are you aware that one of the ministers earlier of yesteryear even resigned for a small rail accident? A minister holding the portfolio of railways submitted resignation, taking responsibility for a rail accident. Those were the days. Leave about the crime.
Your Lordship, only the judiciary can make the person guilty, Your Lordship. He resigned from the ministerial position because for the good governance, Your Lordship. Much obliged, Your Lordship. Your Lordship, the RP Act. Your Lordship, the RPA 1905, Section 8 Clause 3 mandates the disqualification only after the conviction. Comparative constitution follow the same rule. Canada Election Act Section 502 and Singapore Election Act Article 45, Australian Constitution Article 44 Clause 2 and South African Constitution Section 47 1 Clause E requires the conviction. No democratic nation removes elected merely because of the custody, much less custody than may be politically engineered. Thus, the amendments stand isolated, extreme and unconstitutional. Your Lordship, unless Your Lordship has any further question, the Council seeks to give it to that.
Either of you can answer these three issues which come up. At first look, it looks very appealing, your intentions, but the first issue is your stand is that this is an executive post. Now, for the permanent executive like civil servants, if they are arrested and are in judicial custody for more than 24 hours, they are suspended. So, this is also a similar provision. Here at least you have been given 30 days to come out. This is one method. So, this is the suspension. Can be looked as a suspension. This is the first issue. Because you are made the chief minister or minister by virtue of your position in a political party which has come to power. So if 30 days you come out, they can continue you. Because all that is needed is your political party has to say you become the minister again. That is the first issue which comes up. The second issue is you are saying that this is all done without some kind of judicial review. When a person is arrested, he can be arrested only for 24 hours by the police. Any subsequent continuation of that arrest is by a magistrate who looks at the case and takes a call whether this man should be continued in custody. So there is some judicial review. So how does one say that somebody simply arrests and he goes in and he doesn't come out? That's the second part. Now, the third question is, let us look at it practically. Let us say the chief minister of a major state is arrested, kept in jail, 30 days, 45 days. He continues to be chief minister. How does he function as chief minister? He has to get his IAS officers, IPS officers come and visit him in jail. He has to meet public representatives. He has to meet the people with complaints. He has to sign files. He has to hold cabinet meetings. How does he do all that if he continues to remain in jail? So, therefore, isn't it right that he is removed and somebody else runs the government?
Your Lordship, as per the RP Act, Section 803, it states that the only disqualification comes up upon the conviction, Your Lordship.
Here he is not disqualified. It's not really a disqualification. He is only being told he is removed. Once 30 days are over, he comes out, he can be reappointed. This is not to be taken as any disqualification.
Your Lordship, it is stated that it shall be appointed, so there is no procedure, so if there is a gap in that procedure. If he is appointed or again, there is a gap. There is no procedure stating that this is the procedure of appointing them. So it's
procedure after election. If somebody wins, political party wins, the minister or chief minister is appointed for a process. Same process will be followed. Why should there be a new procedure set out? That's not necessary. So how does one answer these three questions? Question number 1, 2, 3. Question number 3 is, after 30 days, what is the solution for a chief minister who sits in jail and wants to run the state from jail? How does it work?
Your Lordship, Council 1 can answer the question, Your Lordship.
Yes, either of you can answer.
That much obliged, Your Lordship.
Council 6 commission to answer.
Yes.
So your lordships have raised a very serious concerns.
Mic on. You can give that handheld mic also because both of them are answering it.
Hello?
Yes.
Is your lordship, am I audible to the honorable bench? Is your lordship, the first question that you have raised, for the answer is that, your lordship, coming to the public servants, they are removed from 48 hours in custody. There is there, but your lordship, they have the chance to file an appeal in the said administrative tribunal, your lordship. But no such judicial scrutiny is not here, your lordship. That is the main concern that their lordship that we have likely to pose. And also in the second issue, your lordship, your lordship, your lordship, the second issue that you have raised was that. Yes, your lordship.
Magistrate.
Yes, your lordship. I understand your lordship's concern. Your lordship.
Doesn't matter.
Doesn't matter.
You can speak, you can speak. You can speak, you can continue to speak.
Yes. Your lordship, even temporary removal may damage the reputation, your lordship. Right to the reputation is there in Article 21, and also it is collapsing the democratic continuity, your lordship. The continuity of the governance is being collapsed, and also there is a prejudice, your lordship. It is on the basis of prejudice, and it is enabling the political misuse. And also, your lordship, it is punishing without adjudication, your lordship. The arrest cannot be an adjudication. The accuser and the adjudicator is the same person, your lordship. That is the executive. Here, the executive is the accusing and the executive is the adjudicator. lordship. And also, the council is not trying to convince that this is not a judicial custody. This is a judicial custody, your lordship. But when from this judicial custody, if there is bail, yes, there is bail, your lordship. Indeed, there is bail. When the person is getting bail and they are removed in that judicial custody, they are being removed. But the trial is pending, your lordship. The trial there might be an abuse of power, and if the same person is coming and doing the governance, who has been removed, and the same person is coming to the same post, and that constitutes an abuse of power, and that constitutes abuse of power. The trial proceedings also, your lordship, and that is the abuse of power, your lordship. That is being constituted. And so this is the way the council would like to prove in the three issues that the serious concerns that your lordship has
The
raised.
practical problem of running the state from the jail.
Yeah, is your lordship, governance from jail is there, but your lordship, the prime consideration is that if a PM, if the PM is having a 5-year tenure, and in the third year, if the PM this arrest is being done, and also 2 years your lordship, there is an indefinite delays in trials and all in our justice system. Your lordship, there is a long procedure for this trial and all, and even after 2 years, that tenure is over. So that is altering the ministerial tenure itself, your lordship. That's how the council would like to answer you. Much obliged, your lordship.
Lordship, council seek the permission of the issues raised, argument advanced, and authority cited, the counsel of the informant most respectfully and humbly pray for the Honorable Court of India that hold the petitioner organization locus and is made amenable for the present public interest litigation, strike down the 130th Constitution.